On the 15th of April this year, in a courtroom in Perth, Western Australia, a judge named Jennifer Smith delivered a judgment that runs to 1,600 pages. That is roughly the length of Anna Karenina, and arguably with a more functional family at the center of it. The judgment concerned an iron ore mine called Hope Downs in the red-hot northwestern corner of the country known as the Pilbara. Hope Downs is half owned by Hancock Prospecting, the private mining company controlled by Gina Rinehart, the richest person in Australia, with a net worth of approximately $45 billion. Justice Smith ruled that Hancock Prospecting must pay hundreds of millions of dollars in royalties, interest, and costs to two rival mining dynasties, the Wright family and the Rhodes family, based on a deed her father had signed in 1987. Within an hour of the judgment, both sides issued press releases claiming victory. This is the corporate Australia equivalent of two people leaving a wedding and each telling the Uber driver they're the bride. The story behind that judgment begins in 1925 in a private boys' school in Perth with two friends. It runs through a low-altitude flight in 1952, a 40-year handshake, a single forgotten clause in a 1987 deed, a 51-day trial in 2023, and a 28-month wait for a judge to write. By the end, you will know why Australia's richest woman is, this month, $500 million poorer. And you will know why the people she has just been ordered to pay are not, in fact, poor either. A note before we begin. This is not a story about whether Gina Rinehart should be richer or poorer. There are other channels for that conversation, and they are easy to find. This is a story about what an iron ore mine actually is, in the legal sense, 90 years after a handshake. By the end of this video, you will know how two boys from the same Perth school built one of the largest iron ore fortunes in human history without ever signing a contract. You will know how a thunderstorm in November of 1952 produced what is now Australia's defining export. You will know exactly which clause, in which deed, signed in which year, in which filing cabinet, just cost Hancock Prospecting approximately $250 million. You will know what Justice Smith actually decided, and more importantly, what she did not yet decide, because the dollar figure has not yet been set. You will know why both Rinehart's own children and her father's former business partners walked into that courtroom asking for a piece of Hope Downs, and why exactly one of those two parties walked out with one. And you will know why the part of this case that gets the headlines, the $500 million, is not the part of this case that legal Australia is actually watching. Let's start at the beginning, the actual beginning. 1925. Hale School is a private boys' school on the western edge of Perth. It was founded in 1858 and has, for most of its history, been the school where Western Australia sends the children it expects to inherit something. Sometime around 1925, two of those children met. Langley Frederick Hancock, born in Leaderville on the 10th of June, 1909. Restless, mathematically literate, and from a pastoral family that owned a station called Mulga Downs, near Wittenoom Gorge, in the Pilbara. Ernest Archibald Maynard Wright, known as Peter, born in Kalgoorlie on the 24th of February, 1908. Quieter, methodical, more comfortable behind a desk than behind a horse. They became friends. In 1938, by then in their late 20s, Peter Wright spent a holiday at the Hancock family station. Mulga Downs is a 500,000-acre property. There is, in 1938, almost nothing else within 4 hours' drive of it, in any direction. The two of them had a great deal of time to talk. By the end of that holiday, they had agreed to merge their two prospecting outfits into a partnership. They called it handwrite. They did not write anything down. Lang Hancock would, decades later, summarize the division of labor in 7 words. He was the business head, and I was to do the field work. No deal between the two men was ever sealed with anything stronger than a handshake, which is the kind of thing you say right up until the moment one of them dies, and his daughter ends up in court. The first thing the partnership found was blue asbestos at Vitinum. The second thing it found took another 14 years to find and was, to a very considerable degree of understatement, somewhat larger. On Sunday, the 16th of November, 1952, Lang Hancock and his second wife, Hope Margaret Hancock, took off in a single-engine Auster light aircraft from Nonyeri Station, intending to fly southwest to Perth. An Auster, for context, is a fabric-covered two-seat aircraft of the kind that pilots from this era described as honest, which is the word people use when they mean extremely small. The weather closed in, bad cloud, low ceiling, no instrument coverage worth mentioning. Lang Hancock dropped the aircraft into the gorges of the Turner River and threaded the canyons at low altitude. Hope Hancock in the passenger seat, both of them having what is technically called a bad day. Lang looked out at the canyon walls. They were, to his eye, the wrong color. The wrong color in the Pilbara is the rust red of oxidized iron. He concluded correctly that he was looking at one of the largest iron ore deposits in the world. One of his biographers, Neil Phillipson, has disputed the precise details of the story over the years. Hancock told it many times, and the version improved with each telling. But the geological conclusion was right. The Hamersley Range and the surrounding Pilbara contain some of the highest-grade iron ore deposits ever identified by anyone, anywhere. There was, however, a problem. The Australian government had banned the export of iron ore in 1938 on the theory that the country only had a small amount of it and ought not to give it away. So in 1952, Lang Hancock had just discovered the most valuable deposit on the continent. And in 1952, the deposit was, in legal terms, worthless. He spent the next 10 years lobbying Canberra to lift the embargo. In December 1960, the embargo was eased. By 1961, it was effectively gone. Hancock and Wright staked the claim. Hancock named the deposit Hope Downs, after his wife, which is, on one hand, a romantic gesture, and on the other hand, the most expensive personalized nameplate in Australian history. In June 1963, Wright signed a royalty deal with Rio Tinto's local subsidiary, Hamersley Iron. The terms were 2.5% of the value of all the ore extracted in perpetuity. Hancock and Wright shook hands again. By the late 1970s, that 2.5% was paying them roughly 25 million Australian dollars a year, split evenly. They had, in effect, bought themselves the most boring and most valuable annuity in Australian corporate history. For 40 years, the Wright partnership operated without a written contract. This is the kind of thing that works beautifully until one of two things happens. Either the people involved die, or there is enough money on the table to make the people involved hire lawyers. Both happened. In 1978, after 4 decades, Hancock and Wright finally signed a written agreement governing their partnership. 40 years of trust written down. The agreement included, at Wright Prospecting's request, a provision splitting the Wright royalty stream evenly between the two companies. In 1983, Lang Hancock's wife, Hope, died of cancer. 2 years later, Lang married a Filipino woman named Rose Porteous. This produced a family situation that has now generated more than 4 decades of litigation, of which today's episode is genuinely only one part. On the 13th of September 1985, Peter Wright died in Bangkok of a heart attack at the age of 77. He left an estate that was, at the time, worth more than $1 billion. Wright Prospecting passed to his 3 children, Angela Bennett, Michael Wright, and Julian Wright. And over the next 40 years, it was administered, expanded, and quietly compounded. By 2023, Angela Bennett on her own was worth approximately 4.6 billion Australian dollars. Her nieces, Alexandra Burt and Leonie Baldock, held roughly $3.8 billion between them. This is not a David and Goliath case. This is Goliath suing a slightly larger Goliath. Now to the document. In 1987, Hancock Prospecting and Wright Prospecting signed a further deed, modifying the 1978 agreement. The 1987 deed allowed Hancock to remove certain tenements from the Han-Wright partnership and develop them as Hancock Prospecting's sole property, including the tenements that would later become Hope Downs and a separate area called East Angeles. What the 1987 deed also said, in a clause that almost nobody outside two law firms appears to have read in the next 38 years, was that even after Hancock removed those tenements, Wright Prospecting kept its half share of the royalty stream over any iron ore eventually mined off them. The 1987 deed sat in a filing cabinet for 38 years. Filing cabinets, it turns out, are not as quiet as people assume. On the 27th of March, 1992, Lang Hancock died. Hancock Prospecting passed to his only acknowledged child, Gina Rinehart, Gina, who at that point was 38 years old, had recently divorced her second husband, Frank Rinehart, and was about to inherit a portfolio of assets and unfinished arguments. She has spent the 34 years since making both the assets and the arguments larger. For the next 15 years, Hope Downs sat in the Pilbara, fully proven, almost entirely undeveloped. The reason was infrastructure. To turn iron ore in the ground into iron ore on a Chinese steel mill loading dock, you need three things: a mine, a railway, and a port. Hancock Prospecting had a mine. It did not have a railway. It did not have a port. The two companies that did, BHP and Rio Tinto, already controlled the existing rail networks across the Pilbara. Negotiations with BHP went badly. Negotiations with Rio Tinto went better. In July 2005, Rio Tinto and Hancock Prospecting signed a 50-50 joint venture to develop Hope Downs. Rio brought the rail. Rio brought the port. Rio brought roughly $1.3 billion Australian dollars of capital expenditure. Hancock brought the deposit. In November 2007, Hope Downs 1 commenced production, about 100 kilometers northwest of the iron mining town of Newman in the Pilbara. In 2013, Hope Downs 4 commenced production, about 30 kilometers north of Newman. In 2018, a satellite open pit known as Baby Hope started up. Together, the Greater Hope Downs complex now produces approximately 30 million tons of iron ore a year. In June 2025, Rio Tinto and Hancock Prospecting announced a further $1.6 billion investment to develop Hope Downs 2. Two new above-water table pits expected to add another 31 million tons of annual capacity, with first ore scheduled for 2027. Across this period, Hancock Prospecting's royalties and joint venture income compounded. By 2010, Gina Rinehart was the wealthiest person in Australia. By 2015, she was one of the wealthiest women in the world. By 2026, her estimated net worth is approximately 45 billion Australian dollars. Almost all of it traces back, through one structure or another, to a flight in November 1952. A short note on the children. In 2010, Gina's three eldest, John Hancock, Bianca Rinehart, and Hope Welker, sued their mother in the Supreme Court of New South Wales over the Hope Margaret Hancock Trust, the family trust their grandfather Lang had established for them in 1988. The case ran for years. It eventually ended with Bianca installed as trustee in place of her mother. John Hancock, born John Langley Hayward, in January 1976, educated at Phillips Academy in Massachusetts, worth somewhere between $2 and $2.7 billion in his own right, has, in interviews since, described inherited wealth in a sentence that probably needs no explanation. It'd be nice if I was, but I have all the bad things about having money and none of the good things. The children, the family friends, and the matriarch all wanted the same thing, which was somebody else's money. They were eventually all going to ask for it from the same judge. Wright Prospecting filed first. Their case was, in essence, that the 1987 deed retained their half share of the royalty over Hope Downs and East Angeles, despite Hancock having removed the tenements, and, more aggressively, that the original 1978 agreement entitled them to half ownership of those tenements outright. DFD Rhodes, representing the family of a third partner, the late engineer Don Rhodes, joined the proceedings with a smaller but parallel royalty claim. John Hancock and Bianca Rinehart joined the proceedings as the third claimant. Their case was that, by a series of transactions starting in 1992, the Hope Downs and East Angeles exploration licenses and the share of the relevant Hope Downs mining lease had come to be held beneficially for them and their siblings, and that those interests had been moved out of the family trust and into Hancock Prospecting in a way they were entitled to unwind. Hancock Prospecting denied all three. Its central position on the Wright case, repeated by senior counsel in court, was that the 1987 deed was, and this is the word that was used, fatal to Wright's claim. The deed, on Hancock's reading, allowed it to take the tenements for its own benefit, full stop. The royalty preservation clause did not, on Hancock's reading, mean what Wright said it meant. The trial ran for 51 days before Justice Jennifer Smith of the Supreme Court of Western Australia. In late 2023, more than 4,000 documents were entered into evidence. The barristers were, in legal trade press headlines, described as gold-plated. The bills, by the time it was over, were the kind of bills that show up in the financial statements of public mining companies as line items rather than footnotes. Hearings concluded in December 2023. Justice Smith then sat with it for 28 months. On the 15th of April 2026, she delivered her judgment. On the Wright royalty claim, Smith found for Wright. The 1987 deed preserved Wright's royalty stream over the Hope Downs and East Angeles tenements, exactly as Wright had argued. Hancock's barrister, who had told the court the deed was fatal to Wright's case, was wrong about which side it was fatal to. On the Wright ownership claim, Smith found for Hancock. The 1987 deed allowed Hancock to remove the tenements, and removal meant removal. Wright did not get to keep an ownership interest in addition to the royalty. On the DFD Rhodes royalty claim, Smith found for Rhodes, on a partial basis. The Rhodes claim succeeded over some, though not all, of the disputed ground. On the John Hancock and Bianca Rinehart claim, Smith was dismissive, in the formulation that was repeated in coverage the next day. The children's claim fails at the first hurdle. Justice Smith then summarized the result, in her own words, in the courtroom. Wright Prospecting won half of its case, lost half of its case, and Hancock Prospecting has won and lost half of its case. Hancock Prospecting issued a statement within hours, framing the result as a decisive confirmation of its rightful ownership of Hope Downs and East Angeles, and characterizing the rejected ownership claims as baseless. Wright Prospecting issued a statement saying it was pleased to finally receive a result in our favor and would review the judgment in detail before determining if any further steps need to be taken. Both sides claimed victory in the same hour, which is the corporate Australia equivalent of two people leaving a wedding and each telling the Uber driver they're the bride. Both sides have, in the days since, signaled that they are likely to appeal. 3 observations about what the headlines are not yet saying. 1. The $500 million figure is, at this stage, an extrapolation, not a court order. Justice Smith decided liability. She did not decide quantum. The actual dollar amount of past royalties interest, and costs that Hancock Prospecting must pay to Wright and Rhodes will be determined in a separate later trial. The numbers reported in the press, approximately of $14 million per year for Wright Prospecting going forward, and approximately of $4 million per year for DFD Rhodes, are go-forward annualized figures. The retrospective component, going back potentially to 2007, is what produces the headline hundreds of millions. The quantum trial will fix the actual figure. The quantum trial has not been scheduled. 2. Appeals are coming. Hancock Prospecting's media statement on the day was framed as a victory. The careful reader will notice that the statement focuses on the ownership findings, the parts Hancock won, and avoids spending much language on the royalty findings, the parts Hancock lost. The reason a corporate press release reads that way is usually that the corporate is preserving its options on appeal. Wright Prospecting's statement said it would review the judgment in detail before determining if any further steps need to be taken. That phrase, in legal press translation, means the same thing. 3. Operationally, the mine does not care. Rio Tinto continues to operate Hope Downs. Hancock Prospecting continues to book 50% of the joint venture income. The royalty obligation is, in commercial terms, a deduction at the back end of a very large income stream. Material to the lawyers, immaterial to the conveyor belt. The shipped tonnage of Greater Hope Downs in 2026 will be, give or take, the same as the shipped tonnage of Greater Hope Downs in 2025. What changes is who, downstream, gets a slice of it. The economist John Quiggin, writing in The Conversation about this case, frames it in terms of Thomas Piketty's concept of a patrimonial society, a world where wealth and social position are dominated by inherited capital, not earned income. The combined wealth of Australia's top 200 grew to 667 billion Australian dollars by 2025. That is roughly 100 times the 6.4 billion total of the first BRW Richest in 1984. Australian GDP in the same period grew about 15 times. On one reading, the Hope Downs case is two clans of inherited Pilbara, mining wealth, fighting over which pile a $100 million royalty stream is on top of. On another reading, it is the same fight Australians have been having since 1788, over who owns the rocks. On a third reading, the one nobody is putting on the news, it is a story about what happens to a country whose largest single export now traces back, through trust deeds and joint venture agreements, to a single afternoon in November 1952, when a man named Lang Hancock got into bad weather over the Pilbara and decided to fly low. 3 things to take away. 1. It is hard to be sure whether two boys at Hale School in 1925 imagined they were founding a partnership that would still be litigating itself in 2026. The evidence suggests no. The Pilbara in 1925 did not exist as a place anyone had heard of. The iron ore export industry in 1925 did not exist at all. The companies that now operate the rail and ports across the region had not yet been formed. The judge who would eventually deliver the 1,600-page ruling had not yet been born. The handshake outlasted everybody who shook on it. 2. The document that did the damage was not the famous one. It was not the 1938 partnership. It was not even the 1978 written formalization. It was a single deed, signed in 1987, modifying an agreement that almost nobody outside 2 private companies had ever seen, that contained one clause that almost nobody appears to have reread in the next 38 years, and that one of the most expensive legal teams in Australia argued in court was fatal to the people who, it turned out, had drafted it for exactly this kind of moment. The most consequential paragraph in Australian iron ore history was, for almost 4 decades, in a filing cabinet. 3. The $500 million is not the story. The story is that the largest single private fortune in Australia is held inside a structure that, when one judge reads one clause one way, redirects a fraction of its income to a different family without any of the operations changing. The mine keeps running. The trains keep going. The ships keep loading. The 30 million tons a year of iron ore that Rio Tinto and Hancock Prospecting send out of Greater Hope Downs do not slow down by a single ton because of Justice Smith's judgment. What changes is the path the money takes after it leaves the port, which is, in the end, what an iron ore mine actually is 90 years after a handshake. If this is the kind of breakdown you want more of, about the things quietly reshaping Australian business, the people who own them, and the agreements that bind them, subscribe. Next episode, that Melbourne logistics company we promised, that moves more freight than Australia Post. We have not forgotten. We will not chase you down the street. Thank you for watching.